SwayamPrabha. Digital India. Educated India.
I am Devojit Kumar Sharma. I will be discussing with you today the topic on restorative justice as part of the course on criminology, penology and victimology. Well, this is the last lecture of this particular course series, and we have named it as restorative justice. So far, what we have seen in our previous lectures, emphasis was on criminal justice. Now, we have changed it to something called restorative justice. Perhaps you may wonder, why is it so? What is the basic philosophy behind it? What are the underpinning values behind restorative justice? What are the principles based on which restorative justice is based on? Whether it is a practice? No, it is not a practice as such defined by any statutes, but these are some of the principles which can be followed. Now, while talking about criminal justice system or parts of criminology, penology and things so on and so forth, the emphasis has always been either on the accused or the person who commits a crime or the person who happens to be a victim of the crime. In fact, during our last lecture, when we talked about victims' rights and criminal justice systems and so on, we emphasize upon the need and requirement of giving rights to the victims parallelly to that of giving rights to an accused, because our system is tilted towards tilted towards accused than the victim. But the question arises, is it sufficient that we emphasize on rights of the accused and rights of the victims? Can there be something beyond that also? And something beyond that is nothing but the very involvement of an important stakeholder in the system, that is the community. I repeat, the community involvement in the criminal justice process or the system is of very great value, and the moment we try and involve community alongside the accused and the victim together and also with other stakeholders, then we get a picture of restorative justice. I am going to explain to you in detail what are the other parameters of restorative justice, but to start with, I am trying to give you a backdrop in which the restorative justice needs to be situated. Now, why I am giving you this backdrop? Again, there is a reason behind it. The reason is very simple. Perhaps I indicated to you earlier in one of my lectures that when someone commits the crime, the person comes from the society. The person comes from the society and the person is being processed through the criminal justice system, and invariably the person has to go back to the same society from where he has initially come. That means the criminal justice is something that cannot be seen in isolation from social system or the social fabric or the social justice as a whole. The involvement of the community where from a particular offender or the criminal comes and to the place, the same place where he or she goes back becomes a very important component, though not defined, but becomes a very important stakeholder in the whole process of criminal justice. Though the society or the context becomes important, but unfortunately not much emphasis is given about the involvement of this important stakeholder, that is the society or the community. But in restorative justice, what is being emphasized upon and what is being given importance to is not only the accused or the victim of the crime, but also society at large and other important stakeholder. Now, there is saying that it is the society which prepares the crime and criminal only commits it. That means, the very conditions of crime causation lie in the society itself. If we go with that kind of an approach, I think you may appreciate the fact that the society's involvement becomes very crucial, not only for the purpose of giving compensation to the victim by the state or the accused, but otherwise also. Say for instance, rehabilitation of the offender. Now, to what extent the traditional criminal justice system or the conventional system of criminal justice administration can cater to the requirements of social control in the society? Is it sufficient that when someone commits a crime, the person is processed through criminal justice administration, and once he comes out of that process after spending quantum of sentence in the jail or prison for that matter, the person becomes a right person, he becomes a reformed person? The answer may not be true in all cases. To what extent such a person is accepted well back in the society by the people at large, that remains a question. To what extent offender in real terms realizes the harm and injury being caused to the victim? Is there any one-to-one interaction with the victim with that of the offender? In the traditional punitive system of criminal justice, this is something not prescribed. But then when we talk about restorative justice, all such aspects are taken into consideration. Friends, what I am trying to bring to your notice here is the fact that the involvement of community in a country like India, which is not homogeneous in terms of communities, in terms of other social processes and social structures, the involvement of community becomes so crucial, which perhaps is not possible to be done through the traditional criminal justice system at all times. This does not mean to indicate that we do not need the system in place, and because that system draws its legitimacy from the statutes, the law gives them legitimacy. It is not that we run parallel system, one is the criminal justice, one other is the restorative justice. But the fact remains that considering the contextual factors from place to place, from state to state, especially in a country like India, there is scope for restorative justice, and this has been proved from time immemorial. We still have some practices in the parts of the country where the customary laws or the customary practices are adopted for the purpose of dispute resolution, especially in terms of the tribal people in some parts of the country. To what extent these practices are in consonance with the human rights standard, that is a different thing altogether to be seen. But the important point to be drawn from such practices is that the very fact of involvement of the community. When the community at large or the society at large is involved in the process of finding solutions to the problems of crime, things become more peaceful. The moment a person is produced before the court of law, the common perception is that the person is a criminal. But in most of the cases, in many of the cases rather, it so happens that the person comes out as an innocent rather than being a criminal. But then that stigmatizing effect that the traditional criminal justice system lifts upon the person is something that can be better taken care of by system like restorative justice. Now, that is the point that I am trying to help you understand here, that we need certain principles whereby there can be better involvement of community in the entire process of criminal justice. Now, though we call it criminal justice, but again all persons who are processed through the criminal justice systems are not criminals. As I have just stated, that many of them comes out as innocent people, they are acquitted, but the stigma that is left, people do not accept them easily. Now, not only in case of accused, but also in case of victims, when they have to give their statements, other than the very serious cases of rape victims and other sexual offences, in other cases when their question of evidence come from the prosecution side also, their evidence have to be produced in the court of law, the police has to collect evidences. Now, that also becomes at time victimizing for the victim of the crime. So, what is perhaps important to realize, that rather than putting these individuals or persons in the society who are very integral part of the society, in fact, both the accused and the offender, I mean both the parties are part of a larger human family. Now, can there be more human solutions to the social problems in the society rather than the very legal solutions all the time? That is where the restorative justice as a method, as a set of principles can be adopted to see to what extent it is feasible. And let me also inform you that communities which are practicing or which are having these customary practices, at times they are resolving conflicts in much better way. There is better reintegration of both the accused and the victim with the larger mainstream of the society, rather than what is being done by our conventional traditional punitive methods and by the criminal justice administration. But this is not to say that everything being done by customary forums are good and fair. There could be cases where human rights are being violated, that is a different thing altogether, but as a matter of fact which needs to be recognized here is that there is learning that can be drawn from such practices, because the involvement of the community is so serious, the involvement of the community is so intense that the community takes care of everyone, be it the offender and the victim, and eventually what happens is that the people can better integrate back to the society where from this thing started. Those conditions as I have told you have to be addressed. Merely by punishing the accused or an offender and by compensating the victim, problems are not going to be sorted out in every situation. What is required is certain better solutions to the problem, so that similar incidents do not occur in future. I mean, in a way, you can also say that restorative justice is based on that philosophy of prevention is better than cure. The moment you start deciding on the cases pertaining to your own fellow human beings by yourself, by the society or the community at large, there is greater involvement. Why should the courts be given that opportunity if things can be sorted out in the community itself? We have in Indian tradition like panchayats, we have the other such forums at the village and at the other level. In the past, they were doing a great job, I mean even now also. But the point here is that if these forums can help resolving other issues, can they be involved in resolving conflicts between individuals unless they are serious offences being reported? I think the answer is yes, and this has been practiced, or this has been in practice in several parts of the country, as I have told you. Now, in this particular backdrop, if I have to take you to the basic concept, philosophy as well as the principle of restorative justice, it would go like this. This restorative justice is primarily based on or focus on relief to the victim in order to raise the victim to the previous level. That means, how do you restore the victim to the previous level? Because it may so happen that once a crime has been committed against a particular person who happens to be the victim of that crime, the person may be traumatized altogether. The several emotional questions may come to her or his mind, that why has it happened to me? I am so innocent. Why this particular crime was committed against me? Am I to be blamed for it, or is it something that I am lacking in, because of which I was targeted? Such emotional questions are not adequately taken care of by the criminal justice system all the time, I would call it. Not, I mean, there are situations where criminal justice functionaries are doing much better job, but then it is not mandatory that those human aspects of either the victim or the offender is not adequately or appropriately taken care of by the functionaries at every situation. Therefore, if we have to restore the victim to the previous level, that is only possible through the involvement of community. Now, the priority of every criminal justice system should be to priority should be to restore that particular previous stage of the victim. After, as I have told you, after the person has been targeted or victimized, it takes time for that person to come back to the previous mental and social standing, and this particular approach helps us to do it in a much better way. Now, not only that, even the offender needs to realize what the wrong or kind of injury he or she has caused to the victim. Many times when we involve the technicalities of law, offender even fail to understand where actually he has done wrong. We do not give him or her an opportunity to realize that what he has done or how his actions amounted to violation of law. Now, that realization comes only when there is an open dialogue between the victim and the offender, alongside the community, and of course, the state entities may also be supporting in such endeavors. Now, as I have told you, these ideals of restorative justice may not be fulfilled through the traditional system of justice, that is through courts and punishment alone, and there is the requirement of every important stakeholder, the victim, offender, community, and in fact the families of these two parties to come together to find some peaceful solutions to the problems they are facing. The moment people talk face to face, many of the problems are sorted out, because the offender also realizes what he or she has done to the victim. Victim can also hear out under what circumstances the offender might have committed that wrong to her or him. That realization comes only when there is an open dialogue, but the traditional systems seldom provide opportunity for such open dialogue. It is rather the matter of cross examination of witnesses, so much of technicalities. Are we as a society, especially in the context like India, ready for it? Even if we are not ready, but then we are bound by the law of the land. But then if you see the efficacy of law, that is something again needs to be debated and discoursed. In a country like ours, we have more and more laws, but less and less justice. People have at times loses faith in the justice delivery system, be it on the part of the victim, be it on the part of the offender. Now, why is it so? If that the very trust and the faith on the system is being lost, the better way is to find some alternative, and this restorative justice is an alternative to the traditional systems, be it call it imprisonment, call it the system, the processes which are involved in the traditional systems, and so on and so forth. And basically it is a problem solving strategy or approach. As I have also told you, it is a conflict resolution mechanism. By the involvement of all stakeholders together, and it cannot be called as a practice as such, but then it can be called as set of principles which can be adopted for better solutions to the problems of crime and conflict in the society at large. The principles of restorative justice are, there could be different principles altogether, but then the main principles could be the personal involvement of whom, the particularly the offender and the victim, as I have told you, and also the families and communities. Personal involvement. In the traditional system, what happens is that not all persons may be called as witnesses. Only those who were present in the scene of the crime, directly or indirectly, they may be called as witnesses. Now, secondly, seeing the very occurrence of the crime in the larger social context where it occurred. That is more of a preventive step or a problem solving orientation. Next is flexibility of procedure. That is what we have as part of our departmental proceedings also at times under the service rules, that we do not go with that standard of proof, that is the beyond reasonable doubt. We go by the preponderance of probability as the standard of proof, that is the based on natural justice principles. Now, what happens here is that we are not even putting such kind of technicalities, we are putting it should be very one to one. Let us not be legal in everything. Many of the problems, conflicts in the society can be resolved through dialogue, through discussion. That is very human way of, more kinder way of dealing with problems. In fact, our courts are also more vocal about similar methods of adjudication of disputes rather than very technical legal methods of doing it. Now, these principles are there, and these principles can be seen in the larger social context, and as I have told you, criminal justice system cannot be seen in isolation from the social justice perspective. It has to be seen in totality. So, the stress of the components in criminal justice, be it police, be it the court, prosecution and the jail, is a very close kind of orientation. The very stress is on closed, I mean everything should be done in a closed manner, non-transparent manner. Now, that is not the case with the restorative justice. Restorative justice says that much can be achieved even without being very close in the orientation or in the approach. Now, one of the main objectives of restorative justice is that to restore or recreate a working community that supports rehabilitation of offenders as well as victims and their active participation in the prevention of further crimes in the society. And that is why I have been emphasizing upon the fact that the voluntary support and cooperation of the society or the community is very integral, as a very much a necessity so far as the success of restorative justice is concerned. Now, going further, what are the elements or rather fundamental elements of restorative justice? The fundamental elements of restorative justice are: number one, crime is viewed in the traditional way in terms of a conflict between the individuals and the society, or rather conflict between the individuals, which results in injuries and harm not only to the victims' communities and to the also the offenders. The aim of the criminal justice process should be rather to create peace in the societies itself, or to create long lasting peace, rather than I would like to put it, by reconciling the parties and by repairing the injuries caused by the parties. I mean, how do we reconcile it? And there have been, let me tell you, there have been several initiatives in India in this direction. We have the practice of community policing prevalent in different parts of the country, which is also oriented on the line of restorative justice. We have the thing called community service, which is being part of Juvenile Justice Act as one of the modes of dealing with a child in conflict with law. And very interestingly, the new criminal law, so far as the general criminal law is concerned, also prescribes community service as one of the forms of punishment. Now, what is that community service? Community service is also nothing but one of the methods of restorative justice. That means, the legislature has also realized that let the community take the final call, let the community be involved and see how much can be achieved, because at times the system fails. System kind of does its job well to the extent of deciding or adjudicating, but what after? After that, is there peace in the society? After that, is there mutual cooperation between the parties, or the parties still see each other as enemies? Can the court really get into those issues and concerns after in the post release stage, or after the person being processed by the system? Now, because the system does not have the legal mandate to do it. If the system does not have the legal mandate, so the better option would be to resort to things like, or the process like restorative justice, where from the very beginning itself community can be involved in the process of reconciliation, in the process of conflict resolution. Now, what are the objectives of restorative justice? The first objective is to fully and in complete manner the victim needs and requirements have to be fulfilled, be it in terms of material, financial, emotional, social. Now, all these needs. Now, what happens in case of traditional justice system, that the other needs may be fulfilled, like the compensation, which might fulfill the financial need of the person or the next of the kin of the victim. But then emotional needs, if somebody has been assaulted or somebody has been victimized, somebody has been kind of raped, it is not sufficient that the person is only paid an amount of rupees, or the offender has been imprisoned, the offender has been hanged till death. But what is also material and what is also equally important is that how that person comes out of the trauma, anxiety, suffering, which might which might trouble that person not only for the time being, but also for years to come altogether. The whole the thing of counseling, I am talking about more in terms of the human intervention, human studies intervention, human relations intervention, the psychological intervention of the victim, that is equally important. And now of course, even laws are talking about that, laws are prescribing similar things to do. Now even we find that under Juvenile Justice Act, now the counseling is one of the methods of dealing with child in conflict with law. It is hoped that similar non-legal intervention might be able to restore the harm caused to the victim. Now another objective of restorative justice is that it helps preventing crimes in the society. And how does it do it? Because it better equip the offender to assimilate himself or herself with the larger mainstream of the society. Third, it aims towards offender taking responsibility of his or her misdeeds or action. When the society's involvement is there, there is always a fear in the minds of any person. I mean, what happens inside the court, nobody is going to look at all the time. The common masses, the common people may not go to the court and to see what happened to my immediate or the next door neighbor when he was caught committing a crime. But what is happening in the community in itself, that is for everyone to see. That means there is an aspect of shame which is involved if the person reoffends. That is why we have this particular theory called reintegrative theory. I mean, the shame should not be to the extent that the person would disintegrate from the society. Rather than doing that, the person should be shamed in a manner that he or she is able to reintegrate back to the society. But unfortunately, what happens in many situations in the courts and in the police, the person becomes reintegrated. Now, that is the reason why we find number of cases, even after the person spends time in the jail, there are cases of relapse, habitual offenders. Nothing goes, nothing can reform them. That means all the methods, strategies being employed by the criminal justice functionaries fail. The moment the person again commit the same crime, one can better imagine what would happen, what has happened to his all resources being put in for the purpose of his reformation by the criminal justice functionaries. That does not work in all situations, but rather than criminal justice functionary doing it for him or her, let the community do it, because there is also aspect of the society may not appreciate the misdeeds of any individual in the society at large, because the society is always mindful about the peaceful existence of human beings, peaceful existence of fellow beings in the society. Now, another very important objective so far as restorative justice is concerned, to restore working community that support rehabilitation of offenders and victim and active in preventing crime, the point that I just narrated to you. And in a way, this also reduces the cost and delays of the traditional justice delivery system. As you know that in the courts, the cases go on for years. We say that justice delayed, delayed justice is justice denied. But then if we resort to such alternative method of resolving conflicts or adjudication of justice, perhaps this may also reduce the cost and the delays which usually happen at the traditional forums or the conventional justice system, and further it would enhance or it would escalate the very aspect of legal justice in the society. Now, what are the basic assumptions of restorative justice? Assumptions. where from this particular idea of restorative justice came. That is we are going to look at later on. Now, before that, let us get into the assumption. The first assumption, as I have told you, it is the society which prepares the crime and the criminal who commits it. That means the conditions of crime. It is assumed that it exists in the society, therefore, the society should take cognizance of the people who commit the crime. Second, crime prevention is based on societies taking some responsibility along with other state entities, maybe at the local and the state level, for remedying those conditions that cause crime. That means the preventive aspect. Let the societies or the community at large work together to address those issues rather than leaving it to the hands of criminal justice functionaries. Now, everyone is concerned about what happens at the time of crime, what has happened, that becomes a historical fact, but very less number of people in a society may be concerned what happens after that. It is not only that the offender has been punished, even the victim at times commits suicide out of that emotional and psychological trauma. Now, if we want to avoid such situations, it may so happen that even after the person being released from the jail, I am talking about a convict, it may so happen that as the society is not willing to accept him or her, he or she might commit suicide. There are cases, I mean, this is the very story of Japan, where they have started this voluntary probation services after a similar incident that occurred there, when an ex-prisoner committed suicide because he had nowhere to go except to commit suicide. Now, the justice measures should be catering to the exigencies of time and context. That is another very assumptions. And beyond that set of assumptions, restorative justice also has certain set of values that it believes in. Now, what are those values? Those values are not different from the values perhaps which are there in the Constitution of India, because if you say our constitutional principles or the values are the common human values, but then this has been shaped in a manner to be called as constitutional values. Number one, respect for dignity of everyone affected by the crime. Now, if we say crime is a disease which might affect the offender as well as the victim, now let us respect, let us see them as not one who are enemies to the society at large, but maybe because of certain circumstances they had to commit the crime, let us respect them. And the best way of doing is, through certain methods like the restorative justice. Now, second important value would be perhaps addressing human needs and requirements of all the participants. In the system like such as restorative justice, that is adequately taken care of. Now, next is offender takes responsibility of what he or she has done, or the harmful behavior that he or she has exhibited. The offender takes the onus is on the offender. Now, in this process, the outcome of justice is also something contributed by the victim, not only something that is decided by the court, and lastly, it helps to reduce crime in the society. There are different theoretical premises, theoretical basis of restorative justice, but there is someone called Howard Jere, and he is said to be the father of restorative justice. Now, according to him, there are three pillars of restorative justice. Number one, who are the stakeholders? Number two, what harm is caused to the victims? And number three, how can the harm be repaired or it can be restored? Accordingly, the very approach toward restorative justice has to be devised, or it has to be accordingly designed. That is what this particular theoretical premise is based on. Now, as I have already mentioned to you about the reintegrative shaming theories, and it is said that someone has observed that the state, under the guise of caring for its citizen, stills the conflicts and hands over them to the courts. Now, is it appropriate? Is it right all the time to do it that you do not let the community or the society decide on the conflicts between them, rather you take it onto yourself and decide on it. So, this as the aspect I already told you, reintegrative shaming, that means shaming should not happen in a manner we should disintegrate the people, but better it is that they are able to reintegrate back to the society or the community. That is good for them, that is good for the society also. Now, so far as restorative justice approach to victims of crimes are concerned, the needs of the victims are at times overlooked in the traditional punitive system, the point that I was trying to narrate to you. How that is? I mean, nobody cares about the victim. Again, if the whole system is more tilted towards the accused, I would call it the condition of the victim may be ignored. Now, if we consider that whatever has happened not only to the victim, but then to us, to everyone in the society, I think the onus shift, and the onus shift towards the community or the society, and that is where the victim is said to be getting more justice than the traditional way of doing it. Now, the proponents of that restorative justice also argue that this is something the rebirth of the ancient practice of healing crimes. I already informed to you that we still have in India certain practices. Similarly, practices which are existing in the communities in India are also there in the parts of the world. Now, should we go with similar practices? But as I have already informed to you, it is not that we are going to run parallel system, but then these systems are important at many times, considering the context, considering the situation which may exist from place to place. Now, in the traditional system, what happens is that there is always the need and requirement of sufficient evidences. Nothing can be proved without evidences, whereas in the process the secondary victimization is also possible. I mean, if the accused has been asked to, or if the victim has been asked to give evidences, now victim is already traumatized. Now, further the criminal justice functionaries or the prosecution is asking him or her to give evidences, or in the court the person is being cross-examined, the witnesses have been cross-examined. Now, is it not something that the person is further victimized by the system itself? To avoid this also, this is something a better option for many situations in many places. Another important parameter to be seen here is that in traditional system, people are less inclined towards reporting crime, or it may so happen that witnesses are at times not very eager to depose before the court of law. Now, if that is the situation, perhaps people will be more willing to come to forums such as restorative justice, where there is a better environment, where they do not have any fear in their mind. There is no police, no court, no prosecution. What you have is people whom you know very well, and they are not going to harm you, they are not going to punish you, but they are there only to resolve your problems, they are there just to help you, facilitate you, so that you become better members of the society. I think this really sounds good, especially in a context like India, where we have many disputes which can be avoided even without going to the court. Now, again, as I have told you, this involves delays, this involves cost, and not every person in a society like India can bear that delay and cost in all situations. Now, so far as the international influence of restorative justice is concerned, it is also very important for us to look at. There is the UN Congress on Prevention and Criminal Justice, which was first held in 1955. And what happens was that various NGOs, they came together working on this theme and formed an alliance called Working Party on Restorative Justice in 1998. Now, this particular group had worked for certain principles to be used for the purpose of restorative justice in criminal matters, and which was adopted by UN Economic and Social Council in the year 2002. Now, this particular development at the international level can be also said to be influencing the the very approach toward restorative justice in different parts of the country. Now, I have already talked to you regarding the various provisions which are there as in our CRPC, so far as the victims compensation is concerned. But then importantly, one of the important amendment perhaps I need to mention here is section 357 capital A, which was introduced in the CRPC by way of amendment in 2009. Now, we have these bodies called National Legal Services Authority, District Legal Services Authority, State Legal Services Authority under the very particular act of National Legal Services Authorities Act. Now, what is the mandate of these bodies is that the more and more involvement of community and the society to find peaceful solutions to the problems of crime and conflicts. That is why we find that even a compensation to the victim has also to be rooted through DLSS. In the case of domestic violence, in other cases, I mean DLSA has been constituted or the state legal services have been constituted so that even the system realize the need and relevance of restorative justice, need and relevance of restorative justice practices or the principles or the assumption. Somewhere down the line you can see here is that we are going towards it, though we still call ourselves as one of the countries which has followed the adversarial method of justice adjudication. Now, you also have the provisions such as section 357C, which requires that all hospitals, be it government or private, cannot refuse to provide free medical aid or immediately to the victims of acid attack or sexual violence. Is it not something in a line of restorative justice? It is indeed. Now, this cannot only be seen to be a matter of compensation to the victim or matter of helping the victim, but also that it is their duty bound to give free medical service, be it the acid attack victim or be it a victim of sexual violence. Now, another thing is that section 358, which often talks about the compensation to the victims of groundlessly arrested by the police. Now, what happens, the earlier the compensation was 1,000, but after an amendment in the past in the year 2005, this has been increased, and now it has been increased beyond that to that particular limit. Earlier it was very less amount, now it has been increased. So, these are some of the very important parameters so far as the Code of Criminal Procedure is concerned, and there are other sections also which are directly or indirectly taking care of the victim's plight or victim's rights. Now, this if we see in the light of restorative justice, we get a complete picture that our laws are also positive about situations or the practice or the approaches as restorative justice. Now, when I mentioned to you regarding the community involvement, perhaps I did not tell you the fact that the Code of Criminal Procedure is not applicable. If you look at the very first section or the initial section of the, not the first, but the initial section of the CRPC, it is stated that this code shall not be applicable to the tribal areas and to the state of Nagaland, except the chapter 8, 10 and 11. Now, why the tribal areas have been excluded from the application of CRPC, whereas if you look at the IPC and Evidence Act, it is applicable. The reason being that so far as the procedure of justice is concerned, at times the tribal communities may not resort to the traditional system, they have their own system of resolving their dispute, and let them do it. We have Article 371 of the Constitution alongside the 6th rule of the Constitution, which gives rights of such customary practices to be prevalent in different parts of Northeast. Now, why is it so? Because these communities or the tribal communities still believe in the virtues such as restorative justice, and that is the thing, that is the special constitutional protection given to them, and this is also something in the light of restorative justice. Now, these customary practices, and the reason why I am referring to it, because it is in the line of restorative justice, is also something that is recognized by the Constitution. Because if we look at Article 13(3)(b), very categorically maintains that law includes any ordinance, bylaw, order, rule, regulation, notification, custom. That means custom is also law. If custom is also law, what is the difficulty to recognize customary practices prevalent among the tribal community? That is the reason why this special constitutional protection is given. I think this is again a very beautiful exposition of how restorative justice is being practiced, but in reality there are of course certain practical difficulties, because the customary laws, when it comes in conflict with other state made laws, which shall prevail. Now, there are certain debates still going on. In case of repugnancy, it is the laws made by the state, be it the assembly or the respective legislature of that particular state, that would prevail over the customary law. That is something, a matter of debate and discussion. Now, another aspect which I informed to you was community service. Interestingly, this point I did not mention to you earlier was that the new changes being brought in by the BNS, the new criminal law, in the following cases. Number 1, non-appearance in response to a proclamation under section 84 of BNSS, involvement of public servant in illegal trade under section 202 of the BNS, attempt to commit suicide, to compel or restrain exercise of lawful power of public servant under section 226 BNS, theft, that is provision to section 303 of BNS, misconduct in public by drunken person section 355 BNS, defamation section 356 BNS. Now, these are the areas where community service can be asked to perform as a punishment. Now, again, the community service is also one of the other ways of looking at restorative justice, because in the process the person actually realizes what the harm or what the he or she can actually see what is that situation under which he has done it, and so that the society also realizes that this person has done something wrong, and the person is realizing it, rather than standing in the court of law or before the police. The person is coming to the community. We also need to be more merciful towards the person. I mean, there could be different objective, but this can be also one objective, and it also helps the person to better integrate. Now, I have told you about the community policing. There are many states in India where this community policing has been practiced, and they have really found good results out of it. Because when the police works alongside the community, the crimes get reduced. There is an open dialogue between the law enforcement agencies and the society at large. Many of the problems can be sorted out by the involvement of common man, involvement of common persons rather, I would call it, and with such involvement, even some of the evil practices can also be addressed. The evil practice, the root of evil practices lie in the society. Now, if one has to address those evil practices, law alone may not be able to do it. And what is very crucial is the involvement of the society in itself. That is what community policing can actually address, and it is being addressed in different parts of the country, as I have told you. Now, another very important thing that is there is that many of the countries in the world at large are resorting to something called community probation. Now, you have two different varieties of probation services. One is the institutional probation and the second is the community probation. Now, realizing the need and relevance of things like restorative justice, they are more and more involving volunteers from the society or the community for the purpose of releasing people on probation. That is also something very interesting to look at. Now, to conclude this discussion today, I would just like to tell you about the limitations of restorative justice. As you may be aware that though it is a very good and sound practice, there are limitations of this practice also. Number one, it depends on the voluntary support of the community, and that voluntary support may not be coming in or forthcoming at all times in all situations. That remains one of the very important limitation, that people may not be willing to participate in the matters of crime and conflict. Though I have mentioned to you about panchayats, but when it comes to somebody doing something wrong to other person, there may not be people who are willing to talk about it. They may not be able to readily dialogue on it. They may be hesitant. So, that is one of the problems. Second is, the society is not structured in a very equal manner. There are a lot of inequalities. So, bringing people together where we have the problems of caste, religion, ethnicity, that may not be possible in every situation if the offender and victim happens to be from different communities or different strata of the society or different kind of groups in the society. So, that also becomes problematic at times. If one person belongs to one religion, the other person belongs to the other religion, or one person belonging to one caste, other person belonging to the other caste, or one ethnicity, the other ethnicity. Now, these problems are the practical problems for the successful implementation of restorative justice. Now, also the communities at all the times may not have those requisite skills and resources to go with restorative justice, because it also requires certain set of expertise and understanding of it, and that is the reason why we have these paralegal volunteers. It is a scheme which was started in India in different parts. I mean, it is still in existence. That is, they are these paralegal volunteers are trying to bridge that gap between the traditional system and the community, and they are more and they are more skilled and they have been trained to do it. So, to conclude again, this is briefly about restorative justice that we have discussed, and I hope it is being useful and kind of interesting to you to know about it, and hopefully India can still have trust in our traditional system, but at the same time we can also look forward to more kind of integration between the traditional as well as the restorative justice practices. Thank you so much.